Dear viewers, in the last session we discussed prospectus and rules relating to issue of prospectus. In this session we are going to discuss remedies for misstatement in prospectus and rules relating to issue of deposits by public companies. The objectives of the lesson are: A. To explain the remedies available to the investor of the company for misstatement in prospectus. B. To explain who are entitled to claim relief from company for misstatement in prospectus. C. To explain who are liable for misstatement in prospectus and what are the defenses available to them. The false statement must relate to some existing facts which are material to the contract of purchasing shares. The purpose for which the money is going to be used is an important fact. In Eddington v. Fitzmaurice, 1885, 29, Chancery Division, 459, the directors of a company issued a prospectus inviting subscriptions for debentures, and by stating that the objects of the issue of debentures were to complete alterations in the buildings of the company, to purchase horses and vans, and to develop the trade of the company. In fact, the real object of the company is to repay the pressing loans. Basing and relying on the prospectus, the plaintiff applied and purchased debentures. The company became insolvent and the plaintiff sued the directors for fraud. The directors were held liable. Lord Justice Bowen said that the directors had misrepresented their state of mind, and a man who lends money reasonably wishes to know for what purpose it is borrowed. Remedy for direct allottis. The plaintiff should have taken the shares directly from the company by allotment. A purchaser of shares in the open and secondary market has no remedy against the company or the promoters, though he might have bought on the faith of the representations contained in the prospectus. The leading case on this issue is Peake v. Gurney, 1873, 43, Law Journal, Chancery, page 19. A deceitful prospectus was issued by the defendants on behalf of a company. The plaintiff received a copy of it but did not take any shares originally from the company. The allotment was completed, and several months afterwards the plaintiff bought 2000 shares on the stock exchange. Subsequently, he filed a case against the directors of the company for deceit. The court rejected the claim on the ground that directors cannot be made liable ad infinitum for all the subsequent dealings which may take place with regard to those shares upon the stock exchange. It also based on privity of contract. According to section 35 of the Act, the following persons are liable under this section. A. Every person who is a director of the company at the time of issue of prospectus. B. Every person who has authorized himself to be named as a director in the prospectus. C. Every promoter who was a party to the preparation of prospectus. D. Every person who authorized the issue of the prospectus. They are liable to compensate the investor for any loss sustained by him by reason of any untrue statement contained in the prospectus. According to section 35 subsection 3 of the Act, the liability is joint and several, and the person who becomes liable may recover the contribution from other equally guilty of misrepresentation. The chief advantage of proceeding under this section is that the plaintiff does not have to prove fraud. If the representation is false, the directors cannot escape liability even if they had made it bona fide and not with intent to deceive. But they have the following special defenses under section 35 subsection 2 of the Act. Withdrawal of consent. A director will not be liable if he had withdrawn his consent to become a director before the issue of the prospectus and the same was issued without his consent. Issue without knowledge. Even where a director's name appears in the prospectus, he can escape liability by proving that it was issued without his knowledge, and on becoming aware about it, he forthwith gave a public notice to that effect. Ignorance of untrue statement. Sometimes a director may be ignorant of the untruth of the statement made on the prospectus. Such a director can defend himself by showing that on becoming aware of the untrue statement, he withdrew his consent by a reasonable public notice. Obviously, this must be done before allotment. Reasonable ground for belief. A director will also be protected if he can show that he had reasonable ground to believe and did up to the time of allotment believe the statement to be true. But under this section, it is not enough for him to say that he was honest. He must go further and show that his honest belief was based on reasonable grounds. Statement of expert. If the untrue statement happens to be contained in the report of an expert, the director has to show that he had reasonable ground to believe and did up to the time of allotment believe that the expert was competent, and if it in some public official document that it was a correct and fair representation. Rescission for misrepresentation. An allotment of shares can be avoided at the option of the allottee if it was caused by misrepresentation, whether innocent or fraudulent. The essential requisite of the action are as follows. A. False representation. There must be a false representation in the prospectus. B. Of facts and not law. The misrepresentation must be of facts and not of law. C. Reliance and inducement. It is further necessary that the plaintiff should have acted in reliance on the statements contained in the prospectus. D. By or on behalf of the company. A company is not responsible for the statements in a prospectus unless it is shown that prospectus was issued by the company or by someone with the authority of the company. 6. Limits of rescission. A. By affirmation. If the allottee with full knowledge of misrepresentation upholds the contract, he cannot afterwards rescind. For example, after discovering his right to rescind, he attends meetings of the company, receives dividends or pays calls. B. Unreasonable delay. He has to take action against the company for avoiding the allotment within a reasonable time after discovering his right to avoid the allotment. C. By commencement of winding up. The right of rescission is lost on the commencement of winding up of the company. Criminal liability for misrepresentation under section 34 of the Act. Where a prospectus is issued, circulated or distributed includes any statement which is untrue, are misleading in form or context in which it is included, or where any inclusion or omission of any matter is likely to mislead, every person who authorizes the issue of such prospectus is to be liable under section 447 of the Act, which provides punishment for fraud. Any person found guilty of fraud may be punished with A. imprisonment for a term which may not be less than 6 months, but which may extend to 10 years, and B. fine which shall not be less than the amount involved in the fraud, but which may extend to 3 times of the amount involved in the fraud, or C. both imprisonment and fine. However, he shall not be criminally liable if he proves that the statement was immaterial or that he had a reasonable ground to believe that it was true. Section 36. Penalty for fraudulently inducing to invest money. It imposes additional criminal liability of imprisonment up to 10 years or fine, or with both, where a person who either knowingly or recklessly has made a false, deceptive or misleading statement, or promises or forecasted or had dishonestly concealed certain material facts to induce another person to enter into A. any agreement for acquiring, disposing of, subscribing for or underwriting shares or debentures, or B. any agreement with the purpose of securing a profit to any of the parties from the income of shares or debentures, or by reference to fluctuations in the value of shares or debentures. Section 37. Action by affected persons. A suit may be filed or any other action be taken under section 34 or section 35 or section 36 by any person, group of persons, or any association of persons affected by any misleading statement or the inclusion or omission of any matter in the prospectus. Section 38. Allotment of shares in fictitious names. The law prohibits impersonation for the acquisition of shares in fictitious name and makes it punishable under section 447 of the Act. Both making an application to a company for acquiring or subscribing for shares under fictitious name, or inducing a company to allot or register any transfer of shares in fictitious name are made punishable under section 38 of the Companies Act 2013. Section 38 subsection 3 of the Act further provides that where a person has been convicted under this section, the court may also order disgorgement of gain, if any, made by and seizure and disposal of the securities in possession of such person. The amount received through disgorgement or disposal of securities under subsection 3 shall be credited to the Investor Education and Protection Fund. Section 29. Initial offer of securities to be in dematerialized form. It provides that initial public offer of any security by a listed company shall be only in dematerialized form so as to comply with the requisite process of Depositories Act 1996 and regulations made thereunder. Section 387. Prospectus of foreign companies. No person shall issue, circulate or distribute in India any prospectus offering to subscribe for securities of a company incorporated or to be incorporated outside India, whether the company has or has not established, or when formed will or will not establish a place of business in India, unless the prospectus is dated and signed and contain particulars with respect to following matters. A. Documents or instruments relating to the formation of the company. B. Rules by which incorporation of the company was effected. C. The name and place in India where above documents of foreign company can be inspected and copies thereof in English language. D. The place, date and country where company has been incorporated. E. In case the company has established its business in India, the principal offices of the company in India with full address thereof. Section 24. Vesting of powers in SEBI. The provisions contained in Chapter 3 running from sections 23 to 42, Chapter 4 running from sections 43 to 72, and those of section 127, punishment for failure to distribute dividend, are to be administered by SEBI insofar as they relate to issue and transfer of securities and non-payment of dividend. The rest of the provisions are to be administered by the central government. SEBI has to exercise the powers in respect of matters specified in subsection 1 and the matters delegated to it under section 458 subsection 1 proviso, and exercise the powers conferred upon it under section 11 subsection 1, subsection 2a, subsection 3 and subsection 4, section 11a to 11d of the SEBI Act 1992. The operation of this section is restricted to listed companies and those which are proposed to be listed. In other respects, the powers are to be exercised by the central government. Section 73. Restriction on inviting deposits. Prior to 1966, there were no restrictions on acceptance of deposits by companies from public, but many companies fail to return the deposits to the deposit holders. It also fails to pay periodical interest to the deposit holders. So, with a view to protect the interest of the deposit holders, the central government had taken the power under section 58A of the Companies Act 1956, section 73 of the Companies Act 2013 to regulate acceptance of deposits in consultation with the Reserve Bank of India. With a view to strengthen the protection of the deposit holders, section 58B was inserted by Companies Amendment Act 1974. It provides that the central government may, in consultation with the Reserve Bank of India, prescribe the limits up to which, the manner in which, and the conditions subject to which deposits may be invited or accepted by a company either from the public or from its members. The provisions relating to deposits are contained in section 73 to 76 of chapter 5 of the Companies Act 2013. Section 73 states that on the commencement of the Act 2013, no company is to invite, accept or renew deposits under the Act from the public except in a manner provided in this chapter. The advertisement or circular meant for inviting deposits under section 73 of the Companies Act 2013 must include a statement indicating the financial position of the company in the prescribed form. For this purpose, a resolution in general meeting has to be passed and rules prescribed in consultation with RBI have to be observed. The company has to file a copy of the circular along with such statement with the ROC within 30 days before issue of the circular. The central government, in consultation with the Reserve Bank of India, has framed separate rules known as Companies Acceptance of Deposits 1975, which came into force on 3rd February 1975. The Companies Acceptance of Deposits Rules 1975 also contain provisions relating to repayment and renewals of deposits accepted by companies before 1975. The provisions of Section 73, however, do not apply in case of banking companies or such other companies as the central government, in consultation of the Reserve Bank of India, may notify. According to the Companies Act 2013, as per Section 73 of the Act, only public companies having such net worth or turnover as may be prescribed may invite, accept or renew deposits from the public as provided in Section 76 of the Act. Other companies shall not invite, accept or renew deposits from the public other than the company's members. According to the present Act, deposit insurance is compulsory for acceptance of deposits from public or from its members. Section 76 of the Act lays down that a company having net worth and turnover of such amount as may be prescribed may accept deposits from persons other than its members, subject to compliance with Section 73, subsection 2 of the Act, and subject to rules made by the central government in consultation with the Reserve Bank of India. Such companies should also contain credit rating from recognized credit rating agency. Rule 3A, promulgated by the central government under rule making power conferred by the Section 73, read with Section 469 of the Companies Act 2013, requires a company to deposit or invest a sum equal to at least 10% of the amount maturing during the year in certain specified accounts in scheduled bank or in specified securities. Any company which has committed a default in refunding the deposit amount taken cannot invite fresh deposits or renew the existing deposits until it has made payment of deposit amount with interest thereon to the existing depositors. This provision shall, however, not apply to banking companies and companies which have been granted exemption by the central government in consultation with the RBI. The depositor may apply to the NCLT for an order directing the company to pay the sum due or for any loss or damage incurred by him, and such other order as the tribunal may consider necessary. The company has to maintain deposit repayment reserve account, and the company should not use this account for any purpose other than repayment of deposits. Section 74, subsection 3, penal provision. The company has to pay off the depositor within the original time or extended time. Any failure in this respect makes the company liable to refund the amount due and also to pay a fine of an amount not less than rupees 1 crore but may extend to 10 crores. Every defaulting officer is punishable with imprisonment, which may extend to 7 years, or with fine of not less than 25 lakhs, but which may extend to 2 crores, or with both. Section 75, damages for fraud. where the failure of the company to pay back depositors is accompanied with the proof that deposits were accepted with intent to defraud depositors or for any fraudulent purpose, every officer responsible for such conduct would also be liable under section 447 and also personally liable for all or any of the losses incurred by the depositors. By going through this lesson, viewers will come to know the remedies for misstatement in prospectus and the rules relating to issue of prospectus. I hope you enjoy this session and we will meet in the next session.